things.
Samson, I submit to you that there is not a modicum of reasonability in the so-called directive, request, or advice from the Attorney General to the Auditor General relative to the publication of audit reports. The Auditor General is the creation of the Constitution, which governs his work. And the Constitution is clear that in the performance of his duties, he is not subject to the direction or control of anybody. The Attorney General is the principal legal advisor to the government, not the Auditor General.
The audit service is part of the public services of Ghana under the Constitution.
But the Auditor General...
The Supreme Court has also said
yes,
that the Attorney General, there's no problem with the Attorney General being the lawyer for the Auditor General.
No, but I'm saying that the Auditor General is different from the Audit Service. The Audit Service is not constitutionally independent and not subject to the control or direction of any person or authority. The Auditor General is constitutionally independent. And so, the Attorney General has no business advising or purporting to direct or control the work of the Auditor General. That is the first point that I want to make very forcefully. Secondly, there is a legal duty imposed on the Auditor General. Let's get it clear here. The Auditor General is not doing anybody a favor. This is not an option he can exercise. There is a clear legal duty imposed on him by Section 23 of the Audit Service Act 2000, Act 584, to publish audit reports immediately. The law says as soon as it is laid before Parliament. Now, how can the Attorney General, the leader of the bar, be advising the Auditor General not to obey the law? Because that is, in effect, that is what he's doing. The law says publish as soon as...
He's saying, don't construe the act separately. Look at the acts in the face of the Constitution and the purport of the Constitution.
Okay, so what he's saying, in effect, is that don't apply what has been written black and white in the law, but work with my personal construction and interpretation of the law. That is how ridiculous that suggestion is. Because you can speak to 10 lawyers and we can have varying positions on the interpretation of a provision. The point is, it is written black and white there. Publish the report as soon as it is laid before Parliament. And so this whole issue about construct the laws holistically, that is your individual opinion. You are not a court of competent jurisdiction. And so you cannot impose that on the Auditor General. In any case, that position is flawed. Samson, because you can only say that the publication of an audit report is prejudicial to the interests of auditees if the auditees were not given a hearing during the audit. But we know that the Auditor General gave all auditees in this particular instance of the audit of COVID-19 expenditure a hearing. And their responses are captured in his report. And so the published report contains the responses of the auditees. How is that prejudicial to their interest? Again, look at the counter proposal he's urging on the Auditor General. Oh, don't publish, lay it before Parliament. How ridiculous. Doesn't the Attorney General know that laying a document before Parliament is tantamount to publication? Because once the document is laid before Parliament and it is not marked confidential, it means it is a public document. Any citizen can access it from the table office or the Public Affairs Directorate or even from the Library of Parliament. So, counterproductive proposal. A busybody who should be focusing on retrieving stolen COVID funds for the state, purporting to advise somebody he is not supposed to advise on breaking the law, when he should be commending him. Again,
whilst this is what is taking our attention, you find that in that letter, there's been a period of collaboration and work between the Attorney General and the Auditor.
Not under this particular Attorney General, the office of the Attorney General.
Including this Attorney General. Or including
this reference to a 2019 letter.
And then
he was not Attorney General.
And then he's seeking to assist the office, form committees to see how they can retrieve monies and the rest.
Over the years, what has been the outcome of that assistance? Zilch, nothing. So it's the usual, attempts to obfuscate issues and prevent.
Right. Let me.
Okay.
this position by the
you come back to me.
This position by the attorney, you've done some 5 minutes left.
Only 5 minutes. Just 30 seconds. Just 30
seconds. Do that.
This suggestion that let the report go to Parliament so that the auditees can have an opportunity to be heard again is neither here nor there. It is not in the Constitution. The Constitution only allows Parliament to do two things: to debate the report, and when necessary in the public interest, refer the matter to a committee to deal with matters arising from the report. Okay. And so they don't validate the report. They cannot amend it. They cannot change it. Even if they disagree with the Auditor General, they can't do anything about that final report.
Right.
Those against whom adverse findings have been made can only go to the High Court to seek redress against said charges and disallowances. It's as simple as that.
Now,